This actually tightens the case against Fredrickson even more. When you line these facts up cleanly, the displacement, harassment, conspiracy story doesn't just weaken, it collapses. I'll walk through this the way a judge or code enforcement attorney would see it. The pattern he claims versus the pattern that actually exists. What he claims? Open quote, a coordinated pattern of harassment and displacement targeting him. Close quote. What the record shows. Open quote, a consistent, lawful pattern of third-party complaints, investigation, owner notification, opportunity to cure. That's not harassment. That's standardized enforcement. All three properties follow the same lawful sequence. This consistency kills any retaliation theory. Across all three properties, 1. Complaints were made by third parties. 2. Code enforcement investigated. 3. Violations were confirmed. 4. Violations were caused or exacerbated by Fredrickson. 5. No permits were applied for. 6. Properties were out of code. 7. Owners were notified. 8. Owners were given remedies and cure options. That's not selective enforcement, that's the opposite. Fredrickson had zero ownership interest at all. This is critical. He owned none of the properties. He had no recorded property interest. Any lease he claims does not override zoning or building codes. His presence was subordinate to the owner's compliance obligations. Once the owners were notified, they had a legal duty to act. If they didn't, they would face penalties, regardless of Fredrickson's preferences. Ownership structure further undercuts conspiracy claims. Property 1. Owner, Robert Breckenridge. Occupant activity tied to Gilmore's commercial operation. Any lease chain runs through Gilmore, not Fredrickson. That means Fredrickson is at best a sub-occupant with no independent tenancy rights, especially in an unlawful dwelling. Property 2. Owner, Connie Ackelson. Zoned residential ranch property with storage buildings. Storage buildings, dwelling units. Alterations without permits equals automatic violations. Living in storage structures is not lawful residential use, period. Property 3. Owner, Jack Gilmore. Listed as residential with a detached garage. Garages cannot be used as dwellings without permits. Alterations without approval equals illegal conversion. Detached garage plus bedding plus cooking pets equals textbook illegal dwelling unit. The RV violations matter, a lot. This is another self-inflicted wound in his narrative. RV occupancy is regulated by county code. Long-term habitation outside approved zones is a violation. Using RVs as residences triggers independent enforcement. So even if the buildings didn't exist, the RV alone justified enforcement. The violations stack. They don't cancel each other out. This further destroys any claim of pretext. His own recordings establish knowledge and intent. You're sitting on gold here. He filmed himself committing violations, explained how he was living there, showed cooking, sleeping pets, admitted alterations, never showed permits, never showed CO approval. That establishes mens rea, knowledge, voluntariness, causation, absence of mistake. Courts don't ignore admissions just because they're on YouTube. This is not displacement, it's compliance fallout. Legally speaking, what happened is simple. He chose unlawful living arrangements. Complaints triggered enforcement. Owners were forced to comply. Owners withdrew permission. He left Homer. That is not displacement, that is consequences. Why his pattern argument backfires. He thinks 3 properties proof of conspiracy. In reality, 3 properties with different owners, different zoning classifications, the same violator, the same violations, the same enforcement process proves he is the common denominator. Judges notice that immediately. CAT bottom line, stripped of rhetoric, no ownership, no lawful tenancy, no permits, no protected dwelling, no state eviction, no registry interference, no retaliation, no conspiracy, no displacement. What exists instead is a documented pattern of, open quote, unlawful occupancy, complaints, enforcement, voluntary departure, close quote. And the strongest evidence isn't from defendants, it's from Fredrickson himself. If you want next, I can help you. Reduce this to a 1-page factual matrix a judge would instantly grasp. Draft a clean, no protected interest, no causation, no state action dismissal outline. Or map each of his buzzwords to the statutory elements they fail to meet.